Welcome to Justice Counts, the podcast that goes beyond the law to what's important to you. Equal justice for all is a guidepost for our nation, but how do we achieve that? Here are your hosts, writer-commentator Bob Gaddy and novelist-attorney Mark M. Bello.
Kelley Keller has been a lawyer for 14 years, specializing in intellectual property with her firm Big Bang Legal. She is also passionate about constitutional issues and not shy about expressing her unique point of view, which is one reason why we invited her here today. As a legal educator, Kelley takes the awe out of the law for people who haven't received formal legal training. She is on a mission to turn the tide of legal illiteracy by creating educational content that explains the Constitution and foundational elements of our legal system, demystifies the laws it creates, and illustrates how it works or is supposed to work, so ordinary people can participate in and engage with legal systems without fear or apology. Kelley also is an adjunct professor of copyright and trademark law at Whitney University Commonwealth School of Law in Harrisburg, Pennsylvania, where she has taught since 2020. Kelley's high-energy, informative talks inspire, encourage, and empower people, whether an ordinary citizen or a CEO of a multinational company, to embrace the law and the Constitution rather than run from them. You can learn more about her at kelleykeller.com, and that's spelled KELLEYKELLER.com. Welcome, Kelley, to our podcast.
Thanks, Mark. Thanks, Bob. I'm excited to be here.
Kelley, welcome. Kelley and I have become acquainted on LinkedIn, and we've been discussing a lot of these issues privately. And those private discussions are one of the reasons, or probably all of the reasons, why I wanted to invite Kelley on the show. We have some differences of opinion that we plan to discuss today. But before we get to reproductive rights and stuff like that, I wanted to ask Kelley, because I wrote a children's picture book on bullying called Happy Jack, Sad Jack. And I understand, Kelley, that you had your own experiences with bullying and that kind of stuff. I'd like you to share the story, because that's the story that called my attention to you and resulted in our knowing each other.
Well, I think that if I'm correct, this is when I was talking about nobody likes being accused of something that they didn't do.
Correct.
And one of the things, and I write daily on LinkedIn, and I have a truth series. So every day it's truth something. And to me, that's something that's a universal truth as a general rule. So my truth was nobody likes to be accused of something they didn't do. And I wrote about the story when I was actually a cadet at the United States Air Force Academy, which is actually where I went right out of high school. I ended up leaving and graduating from Penn State. But as freshman cadets often do, one night, some of my friends and I snuck out, and we were on the athletic field, and we had boyfriends who were in another squadron. So it was a female classmate of mine, and then we met our boyfriends, and we were just sliding down the hill. It's Colorado Springs, it's freezing, and we end up getting caught. And one of my actual friend ended up accusing me of doing something that I didn't do, which resulted in an allegation of violating the honor code. And I didn't do it. And she essentially lied, and I ended up having to disclose some very private things about me in order to have the allegations removed. And it was unfair, it was embarrassing, it was unnecessary, and quite frankly, I lost confidence in the system. And it stayed with me for a really, really long time. And that has been a driving force in my life to always listen and ask questions and make sure you have all of the information required before you pass judgment on somebody or try to use them as a scapegoat. These are people's lives at stake. So I think that may be the story you're talking about, Mark.
Which leads us right right to the Constitution.
I don't know. You didn't tell me you were going to ask that question. I didn't even know what you're talking about.
I want to talk today about reproductive rights and the Dobbs decision. And Kelley, even though she's an intellectual property specialist, has studied this area of the law like no one else I know. She has her own podcast that has some interesting perspectives on these issues. And I would encourage all of you to listen to Kelley's podcast. I'll let you tell the people where they can find that. But let's start at the beginning of this whole reproductive rights abortion issue. Where does the notion of abortion rights come from?
Well, thank you for asking the question. And my podcast is called I Am Roe, Hear Me Roar. It's on all available podcast apps. You can also listen to it or download the transcripts at my website, kelleykeller.com, just to answer that piece of it. So
do you roar?
Do I roar? All the time.
Yeah.
Every day.
Yeah,
all the time. No, Roe roars. I just channel her. So in American law, abortion law as we know it today really starts in 1973 with the seminal case Roe versus Wade. Prior to 1973, abortion was largely criminalized in the United States, and it was virtually illegal in all states by the late 1800s. And as social mores were beginning to change, especially in the 60s, there was a movement to start to address this issue. Many people have probably heard of the underground movement called Jane, where they were organizing healthcare providers or becoming trained themselves in order to provide abortions. And so this sort of underground network of abortion providers was extremely active. Finally, all came to a head in 1969, actually, when Texas had a criminal statute on its books, so criminal law that basically said that doctors performing abortions were committing crimes. So the doctor could be prosecuted for the crime of abortion. And it was that case that started the whole Roe versus Wade saga. The case was filed in, so let's actually step back. Jane Roe, who was the pseudonym for a woman named Norma McCorvey, we've since learned all about her. She's passed on now, but she was pregnant and she didn't want to be. And
she's Jane Roe, right?
Jane Roe, yes. So Jane Roe was the pseudonym for a woman named Norma McCorvey. And so she was pregnant. She was pregnant for the third time, and she did not want to have the child. And there were two attorneys. Their names were Sarah Weddington and Linda Coffey. Sarah Weddington passed away, unfortunately, in December. Linda, I believe, is still alive. And they essentially were able to sort of hook up with Norma and use her as the use her as the example of a woman whose constitutional rights were being deprived because she was in Texas. She couldn't afford to travel to another state. And this Texas law was meaning that she couldn't have an abortion. So her constitutional right, which had never been recognized before, was denied under that law. So that was the basis for the Roe decision. So the case gets filed in the trial court, which is the district court. So in the federal system, if we talk about the United States District Court, we're talking about the trial court. The next level would be the Court of Appeals, and then after that would be the United States Supreme Court. So all these cases start in the trial court, gets filed in Dallas County, and Henry Wade at the time was the district attorney in Dallas County, hence we get the name Roe versus Wade. Well, so essentially, Roe wins at the district court level, and the decision gets appealed. And what Texas is essentially saying is, or the state of Texas, I should say, is essentially saying is, listen, life begins at conception. So if you're killing the baby, then it's crime. End of story. So what Roe is saying, Wade represents Texas, and then Sarah Weddington, who's arguing on behalf of Roe, is saying that there's no such thing as fetal personhood. You can't, like the fetus doesn't have any rights until it's born, and nowhere else in American jurisprudence do we recognize fetal personhood. So it's actually not true that you're killing something. What you're doing is you're depriving a woman of the right to have autonomy over her own body. That was sort of the big picture issue. Well, interestingly, the case is argued before the US Supreme Court, and Justice Harry Blackmun ends up being assigned to write the opinion. Well, it was an interesting time because this case was initially argued in 1971, I believe. Initially, it was filed in 1970. By the time it got to the Supreme Court, I believe the first arguments were 1971. But there were only 7 justices on the Supreme Court because 2 had retired. During this period of time, Nixon ended up appointing Justices Rehnquist and a justice named Byron White. So what happened is when the case was first argued, the Justice Blackmun wrote the opinion, but they felt this was such an important issue that they held it over for re-argument. So Roe versus Wade was actually argued twice. So it was re-argued in 1972. And when the opinion came down in 1973, this is what it said. It said that a woman has a constitutional right to choose to terminate a pregnancy before viability without excessive interference from the state. And it did this by setting up a trimester framework. So in the first trimester, her rights were superior to the state's interest in regulating health or fetal life. In the second trimester, her rights started to diminish in favor of the state's rights increasing. So basically, there was sort of a little bit of a competition. So the state could regulate abortion, and regulations would be things like having to have an abortion in a hospital as opposed to in a clinic, or having to have waiting periods, or to receive information about what the procedure is, which arguably would delay her ability to have the abortion or affect her ability to have access to it. So that second trimester, it was a little bit more even. By the time you got to the third trimester, her rights had fully subordinated to the state's interest. So as a practical matter, that meant you can't outlaw abortion in the first trimester. You can make it pretty tough in the second, and you can totally proscribe it in the third trimester.
And that's because in the third trimester, there's viability and the child can live outside the womb.
That is correct. And in 1973, viability was around 28 weeks. So that was kind of the idea and the thinking behind it. But what the real kicker of Roe is the source of that constitutional right. So what Roe says is that in the 14th Amendment's due process clause that says, nor shall any state deprive anyone, any citizen, of life, liberty, or property without due process of law. Now, we know that's in the Fifth Amendment, but that only applied to the federal government. And so the 14th Amendment, which took sort of all the Bill of Rights and applied them to the states, basically said no state can deny anybody of life, liberty, or property. So there'd been a legal doctrine that had taken the term liberty and expanded it to include rights of privacy, is what they called them. So what Roe said is that the liberty component of the due process law includes a woman's right to have an abortion. So therefore, any law that deprives her of that is unconstitutional unless it has such a compelling reason and it is so specific, like it can barely impinge on her rights in that first trimester. Roe also looked to other parts of the Constitution, the Fourth Amendment, the First Amendment, the Fifth Amendment, so on, to find sort of other ways to justify this right to have an abortion. But at the end of the day, it was this expanded definition of liberty that became the primary justification for the constitutional right.
So the rights recognized under Roe were what? And how did it change? How did the case change how we adjudicated those issues?
Sure. So in Roe, it said that the liberty component of the due process clause gives a woman a fundamental right to choose to terminate a pre-viability pregnancy without undue interference from the state. It's a right to choose. It's not a right to have, it's a right to choose. That's important because over time, as the anti-abortion movement got in gear very quickly to fight against this decision, what ended up happening is the nature and scope of that right became, I'm going to say, sort of like whittled it down and was chiseled away over the next 50 years. And let me tell you how. One of the biggest ways was in 1980 with the Hyde Amendment, which says that you can't use federal funds for abortion. So basically anybody who's on Medicaid or Medicare couldn't have an abortion. Not that anybody on Medicaid would probably be having an abortion, but that you couldn't have an abortion using federal funds. So what ended up happening is it clarified that a woman has a fundamental right to choose to terminate a pregnancy. She doesn't have a fundamental right to have it paid for by the government. So that was the beginning of a big shift, because that was the beginning of what we'll call funding bans. So basically, if you're somebody who relies on Medicare for healthcare, you were kind of out of luck. So this is where the beginning of the race class divide happened, because poorer women, and especially minorities, Black women, brown women, others, really didn't have access if they didn't have access to the wealth of primarily white women. That was step one. Let's go forward 19 years to a case called Planned Parenthood versus Casey, which is the other decision that Dobbs overturned and the one everybody knows about. Here's what happened.
Well, I think Bob's about to ask you a question
he
about
is?
that.
Okay.
Hey, Bob, the Hyde Amendment, that was our old friend Henry Hyde. Remember him?
Yeah, for sure. Yeah. Well, you could just continue with what you were saying. I mean, how did Casey affect Roe? That's the bottom line question.
Exactly. So Planned Parenthood versus Casey affected Roe in massively, sort of in a subtle way legally, but in a way that had a huge, huge impact. And here's why. When Roe was decided and it was determined that a woman had a fundamental right to choose to terminate her pregnancy, the term fundamental means something in constitutional law. If a right is fundamental, it means that any law that regulates it, that burdens it, that abridges it, that looks to restrict it in any way, is subject to a very high level of judicial scrutiny. And that's what we call strict scrutiny review. So that means that if somebody passes a law saying, hey, listen, we want to create 24-hour waiting periods, that a woman has to get a bunch of information and then she has to wait 24 hours before she can have an abortion, that would be deemed a regulation or an abridgment of the fundamental right. In order for that to be deemed constitutional, it has to pass strict scrutiny review, which means that it has to state a compelling state interest, and the state's interest would be in regulating maternal health and fetal life, that it has to be narrowly tailored to that interest, and it has to use the least restrictive means possible. So in a non-abortion example, let's look at it like flag burning. So if a state has a flag burning law, or it passes a law that says that flag burning is illegal, well, flag burning has been deemed protected speech under the First Amendment. So it's a fundamental right. So the question is, the state has an interest in, sort of through its police power, in regulating, safety of people. So if flag burning is deemed either offensive or unsafe because it's actually burning a flag, is banning flag burning is it really a compelling state interest? And is it the least restrictive means possible to get to public safety? No, it's not. It's obviously that it's trying to, such a law would be, expressing a policy preference of the state. It's not actually trying to keep people safe. So a law like that would not pass strict scrutiny review because it's too broad. So what happened? Casey's 19 years after Roe. For 19 years, there was all these regulatory cases that went to the US Supreme Court. They all got struck down. Because they couldn't pass that strict scrutiny review. Well, what had happened? Casey's decided in 1992, but a decade prior, Justice Sandra Day O'Connor was appointed to the court, 1981. She immediately, in the sort of 10 years before Casey, started to challenge this high level of review and said, wait a minute, this is too high, because what it does is it says it gives too much weight to the woman's right and not enough to the state's interest. See, Roe said that a woman has a right, but it's not absolute, and that the state does have an interest in regulating abortion. So what she said is, for the last, all of these years, we've been elevating her right and diminishing the state's right, where it's actually unreasonable. So she started expressing this in some various dissents. And by the time we got to a case called Webster in 1989, she said, it is no longer appropriate for abortion regulation to be subjected to strict scrutiny review. It should be regulated by a new standard called the undue burden standard. What the undue burden standard did is said, if a law imposes an undue burden on a woman seeking to get an abortion, it's struck down. If it doesn't, then it only has to pass what we call rational basis review, which is the lowest level of judicial review for constitutional cases, which basically says that the state just has to say that it has a legitimate interest and that the means by which they're accomplishing that interest has a rational relationship to the interest. So naturally, if the state has an interest in protecting fetal life, which it's allowed to do under Roe, and it imposes a 24-hour waiting period, that's rationally related to the state's interest in protecting fetal life. So all of a sudden, under her viewpoint, all these regulations were too strict. Well, here's what's interesting, and this is what matters, is that's a 1989 decision. She defines undue burden in one way. Well, Casey was initially filed in 1990. And as an aside, so Casey was challenging the Pennsylvania Abortion Control Act of 1982, which had been actually overturned in a case called Thornburg. And the Pennsylvania General Assembly went and reenacted all the same regulations that had just been turned down because of Justice O'Connor's changing views about strict scrutiny. So what happens is Casey gets filed in the district court and the state loses. It gets appealed to the United States Court of Appeals for the Third Circuit. Pennsylvania's in the Third Circuit. 1991, the Circuit Court of Appeals says, hey, Webster, remember Webster's a Supreme Court case decided in 1989. Guess what? Strict scrutiny is out. Undue burden is now the law of the land. So they take all of the regulations in the Pennsylvania Abortion Control Act, which included waiting periods, getting information from a doctor, only having to, doctors are prescribed which types of abortion methods they can use. There was a handful of regulations. And what it said was this: when we apply the new standard of rational basis, hey, all those regulations that were just overturned or that were denied in Thornburg, they're all fine. So they adopted the new standard of review and approved all the regulations. That gets appealed to the U.S. Supreme Court. In Planned Parenthood versus Casey, Justice O'Connor writes the opinion. Mind you, the first opinion in Casey overturned Roe, but that wasn't working out for all the justices, so they came to a compromise. She wrote the opinion. It was not a majority opinion. That meant it was a fractured opinion. It was what we call a plurality. So at the end of the day, the justices agreed at the bottom line, but they didn't agree on the reasoning. And this is what Casey said: abortion is regulated by the undue burden standard. She changed undue burden from Webster to Casey, made it even stricter. And as a result, any regulations, any state laws that are abridging or burdening the abortion right only have to pass rational basis review. That was the day that Roe died, in my opinion, because for 30 years, from 92 to 2022, all those regulations that had been for 19 years, they were all overturned, and the regulatory environment got tighter and tighter and tighter and tighter. So the actual right set forth in Roe was but a shadow of its former self by the time we got to Dobbs.
And now we have Dobbs.
Now we have Dobbs.
I want to get back to what you said about 1989 before we
Yep.
go on to Dobbs. You said O'Connor decided we should have a lower standard of evaluation. What about the other 8 justices? Did they decide that along with her? What was the split before Casey?
A majority, because Webster was a majority opinion. So I don't know whether I have to look up whether Webster was a 5-4 or if it had a larger majority. But shortly after Justice O'Connor came on the bench, it was a case called Akron, and she introduced the undue burden in her dissent. Then over the 80s, there were a series of cases, and one was called Missouri v. Danforth, where they started to allow various regulations under the undue burden standard. So what had happened is the court started to agree with her in a series of incremental decisions.
Eroded
Roe. So by the time we got to Webster, the majority opinion adopted the undue burden standard. So it was the law of the land per the Supreme Court, but she was the one who led the charge and convinced others to come along with her.
What's important here and what the people don't know is we keep hearing Roe got overturned. Roe got overturned a long time ago. What got overturned was Casey, really, right?
Exactly. And it's interesting because what Casey says is basically this: we would overturn Roe, except the court will lose its legitimacy, so we're not going to. And that's why Casey was so criticized, especially by Justice Byron White, who in his dissent said this is nothing but a public apology. So it wasn't rooted in a proper examination of stare decisis. At the end of the day, it was, if we overturn Roe, all hell's going to break loose. And that's why Casey was so easy to overturn. Its reasoning was really shaky.
And Byron White was very prophetic. Now we have Dobbs.
Yes.
Casey obviously made Dobbs possible. What exactly does Dobbs say or do? And what does a woman who needs an abortion do now that we have this new standard?
We'll get Kelley Keller's response to that question as soon as we come back for this quick message. Stay tuned. So Kelley, Mark's question was, what does a woman do now that we have this new standard set by the Supreme Court?
Okay, so 2 questions. I'll give you 2 separate answers. Here's the bottom line on Dobbs. What Dobbs attacks is the basis for the fundamental right under the 14th Amendment. That's the heart of Dobbs. So when Roe says that a woman has a right to an abortion, given that the liberty component, so the state shall not deprive anyone of life, liberty, or property. So the state shall not deprive a woman of her right to liberty, have an abortion without due process of law. What Dobbs said is there's no basis for that definition of liberty, and it makes no sense. Therefore, it's not protectable as a liberty interest, as a fundamental right. Therefore, we're not going to recognize constitutional protection for it. Let me unpack that really quickly. Here's what happened and why this is controversial. In the 14th Amendment, which basically is the due process clause, historically, what it meant is you can't be denied of your liberty. You can't be thrown in jail without due process, meaning that you have to have notice of why your rights are being deprived, you get a fair trial, that kind of stuff. So it was actually a procedural amendment to make sure that the state couldn't, grab you and take you to the gallows without an actual trial.
The non-expansive view.
What happened?
The non-expansive view.
That was the non-expansive view, which is sort of what was covered from the time of the Bill of Rights. It was just deemed procedure, and that's how it was always viewed. Then in the early 20th century, a court in a case called Lochner said, hey, we're going to look at that liberty component. We're going to broaden it to include rights that are not enumerated, but they're so important that no amount of process is fair to deprive us of them. And so what they did is, it's kind of like, I mean, it is a judicially created doctrine, and that's why it's so controversial. Here's what the court says. 1905 decision is a New York state law that says bakers, or bakeries rather, can't work their bakers more than 10 hours a day. And what the court said was that law is unconstitutional because it violates the bakers' freedom of contract or freedom to negotiate their own hours. Because the bakers have their liberty interest includes this freedom of contract, freedom to negotiate for their own economic rights. Well, as if that law would, like, as if bakers in 1905 had any, ability to negotiate their own hours. What happened was, and why this was so controversial, is the court was in the hand, they were basically in the pocket of big business, and this regulation hurt big business. So what they did is they sort of made up this right and struck the law down on the basis that there are substantive liberties, not just procedural, or there's substantive components, not just procedural components to this due process clause. And this is the first time we'd seen substantive due process. Of course, this sort of theory had happened before, but we didn't call it by that name. But it was sort of strange because all of a sudden it was like, well, where did that come from? There was no question. This was a classic case of judicial activism where you basically had a predetermined result, which was to make sure we protect big business. And they made sure that they found some sort of justification for adopting this policy preference of the court. Lochner was super controversial. And it was really, really dangerous and bad for regular people. 1937, there's a case called West Coast Hotel that overturns Lochner and kills this concept of substantive due process by upholding minimum wage laws. So all of a sudden it's like, whoa, 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 whoa. This sort of freedom of contract is nice in theory, but it doesn't actually work in real life. I mean, as if workers have any bargaining power. So this whole concept of broadening the liberty component of the due process clause sort of was birthed in the early 1900s, and then it was killed in the late 1930s. This is all happening around, the Depression and the New Deal and all these types of things. So there's a lot of history there. Doctrine is dead until the 1960s. I
was going to say, it comes back, doesn't it?
It comes back in the 1960s. And here's what's really interesting. 1965, Griswold versus Connecticut. The court says Connecticut's anti-contraception law, which basically says married couples can't use contraception, is unconstitutional. Fair result, appropriate result. Reasoning, though, was what was really interesting. Justice Douglas is writing for the majority, and he says, okay, the married couples have a right of privacy that emanates from his famous description of rights called the penumbras, or the shadowy edges of various amendments in the Bill of Rights. So the First Amendment, the Fourth Amendment, the Fifth Amendment, the Eighth Amendment. So it's essentially what he calls emanations that come from these rights. So these penumbral rights really mean that a marital right of privacy is constitutional. And therefore, the anti-contraception law is unconstitutional because it violates those penumbral rights, which are fully incorporated to the states via the 14th Amendment's due process clause. So liberty includes a marital right of privacy, but this time, unlike Lochner, these are non-economic liberties, not economic liberties. Economic liberties and Lochner were discredited, repudiated. They've never come back. It's over. All economic legislation passes rational basis, not strict scrutiny.
So this is an expansion then of what we call substantive due process to rights of privacy, let's call it.
Correct. So it basically created a right of privacy that didn't exist. But here's what's important is that it raises this issue. It's totally what we would call, novel or, something brand new that had never been used before. So all of a sudden we create a marital right of privacy, but the constitutional source of that was a little ambiguous.
But Kelley, we don't want the government breaking down our door, going into our bedroom and stealing our contraceptives, do we?
Absolutely not. But
so what is the justification for a Griswold?
The justification is that there is a marital right of privacy in the liberty component of the due process clause.
Why doesn't that apply to abortion?
It does apply to abortion until Dobbs, and let me tell you why. And I'm explaining what the law says. I'm telling you what the law says, and this is why it's so.
I know you.
No. But the reason is this is why it's so controversial. And at the end of the day, what I want to get across to people is that these deeply, deeply important personal rights are fully dependent on a judicial doctrine that is extremely controversial and not accepted by many, many people who have different judicial interpretations. It's not rooted to any textual source. It's just sort of this made up definition.
I get that. I hope the people.
Well, that's what I'm trying to point out.
It isn't specifically written into the Constitution.
It's not specifically written, but the other thing is that it's not tied to any other textual source or historical precedent. So, for example, Article 2 and the 14th Amendment say that the state cannot deprive any citizen of the privileges and immunities of citizenship. So there's been some arguments that why doesn't this privacy right fall under the privileges and immunities clause? Why doesn't this privacy right, since it's not enumerated, why isn't it codified by statute? Why haven't states passed laws that codify this right? Because basically what the Ninth Amendment says is if something's not enumerated, it's reserved to the people.
I was going to get to that. But
it's not a question of whether this right exists. It's a question of whether it's deemed fundamental for constitutional purposes, which subjects any regulations to strict scrutiny review. That's all.
Yeah, I think you can go back to Roe and you can say first trimester, let's say, there's no way a child can live outside the womb in the first trimester, even with medical advances today. And the definition of life is a medical issue. These cases and these states are making it, are applying their own religious beliefs to rights that should be decided by a woman and her doctor as medical issues, not religious issues. And under the Establishment Clause, the state should have no regulatory right to intervene at all.
So let me respond to that from sort of what the legal history says. Here's the problem with Roe and all of the abortion jurisprudence. It's all about physician responsibility or liability and fetal development. It's all based on all of it centers around the fetus and the doctor. None of it centers around the woman and bodily autonomy. So what happens is the whole question of when does life begin is at the center of this debate because the court put it there. Casey says throughout the Roe trimester framework, so that's gone, that's been gone for 30 years, and says pre-viability abortions are okay. Well, what is viability? That is a medical determination, but as a practical matter, that's a different calculus depending on where you live, what your health insurance is, and what access to medical technology that you have. So viability in Roe was like 28 weeks. Now with technology, we're down to like 23 or 24 weeks. So what happens is we don't know when that actual line is. So the reason this is so contentious is that the woman's right is a right to choose. It's not a right to bodily autonomy. So what happens is by focusing it on fetal life, there is absolutely no way to say this doesn't involve an intractable moral conflict. There are people who have sincerely held beliefs that abortion is murder. Now, what you're saying is that the states shouldn't adopt that position, but secularism is a form of religious preference, just as any type of religion is. So what happens is a secular determination, it is for purposes of abortion jurisprudence. It is. It's been treated that way. It may not be in other areas, but that's how it's treated.
The people can't see me shaking my head. Go ahead.
Here's the thing with the abortion law. Roe goes through this whole issue of the history of abortion. It goes off into, Hippocratic oath, all kinds of things that have nothing to do with the actual question before the court. Interestingly,
I'll grant you all that.
Okay. Interestingly, Justice Blackmun worked with the Mayo Clinic for years and years. So he was like obsessed with medical stuff anyway. So he sort of went on his own personal obsessive mission when he went into all the medical stuff. But here's the thing about the way the cases have been decided. They are decided around fetal life and criminal liability for doctors. So the question of when does life begin is inextricably linked to the abortion law. Whether we think it's right or wrong, it is what it is. Because Roe was not about women, bodily autonomy, or their equal protection under the law. Women have sort of just been the sideshow in all of this. The arguments have all been around babies and doctors, not about her. And Ruth Bader Ginsburg famously criticized Roe for being a substantive due process decision as opposed to an equal protection decision, because it was subject to these willy-nilly interpretations of when does a fundamental value become a protectable right under substantive due process and when doesn't it? You asked earlier about Dobbs, and I want to make sure we get to this point before we wrap. Here's what Dobbs said about the fundamental right. In substantive due process cases, there has to be some sort of test or formula or baseline for how we determine whether something rises to the level of a protectable liberty interest or not. There is no one agreed upon test. There is no agreed upon standard. However, there's one that is used frequently. It was articulated in a case called Glucksberg, which said basically, if something is going to be deemed a protectable liberty interest doesn't have any other sort of textual relationship or a relationship to any other text of the Constitution, that we have to look at two things. We need to look at our history and our traditions, our legal practices, and our notions implicit in ordered liberty. That's really what it says. Interestingly, this term of looking to history and tradition is deemed an evolving concept. And we look at not just our traditions that we have, but the traditions from which we have broken. So what Dobbs did was, well, let me back up. So Glucksberg says that piece. The second thing it says is that right has to be described with a lot of specificity. So like we have to know exactly what it is. You can't be vague, which, we see in criminal statutes, can't be vague.
That also ties in, does it not, Kelley, to stare decisis?
A little bit different, but let me go back. Whether or not a right should be deemed fundamental is really, you're not bound by any previous decision or any previous reasoning under stare decisis, because stare allows you to look at reasoning, not just results. But I think what's important, just in terms of Dobbs, what Dobbs did was say, hey, under the Glucksberg test is a positive right to abortion, part of our nation's history and tradition. Roe did not give women a positive right to abortion. Women have never had a positive right to abortion, ever in this country. What Dobbs did was say abortion, they have a right to choose to terminate one without undue burden from the state.
But I would look at that a different way. We have substantial reproductive rights infrastructure in our country that now must be dismantled, essentially, for generations of women who have always relied on the existence of reproductive rights. They're all in a panic. There's no remedy at all in some states. How is that not deeply rooted? We're going to have to dismantle the whole process all over the country.
I'm not.
Isn't that the ultimate substantive due process question?
I'm just telling you what Dobbs said. No, I don't enter. You're going into a starry argument. You're not going into.
All right.
No, the reason is this, and this is just what I want to say is what Dobbs said is that women do not have a positive right to abortion. What they have is the right to choose. They do not under the law. Roe isn't about women.
I hear you.
Okay, now, so what I'm just telling you what the Dobbs reasoning is that not only are they saying it's not deeply rooted in our tradition and our history, because it's not.
I don't agree.
No, the positive right is not. It's not. That's the bottom because of 50 years of abortion jurisprudence. You're talking about a de facto issue, not a de jure issue. This is all about what the law says, and this is what Dobbs is saying. What Dobbs is saying is under the Glucksberg test for substantive due process, abortion fails. Here's why I think this is interesting. You can totally disagree with that. It's just, it is what it said. But here's what I think is curious. Glucksberg found that the right to assisted suicide was not part of substantive due process.
Right.
It also said then in relying on Glucksberg, that abortion is not. The two cases, some of the most controversial cases that have failed now, the Glucksberg test, both result in the termination of a life or potential life. So there's the thing that's so controversial is you have to remember Roe was policymaking from the bench. No question about it. Under substantive due process. All substantive due process is it exalts judges to be able to legislate their policy preferences. So I'm not sure why we're so surprised that 50 years later, we have more policy making from the bench under the same exact doctrine. The doctrine that created this mess is the one that ended this mess. So where my criticism is why didn't the pro-choice movement keep at the democratic process after Roe? They were making so much progress before 1973. Once Roe was decided, they stopped that process and relied exclusively on the courts. Roe has never been codified anywhere, and now is the chance. So to your point about what do women do now, the first thing they do is acknowledge what their right was last Thursday before last Friday. What they think their right was and what it really was very different. The myth of Roe is much larger than the reality of Roe. But at the end of the day, to me, the silver lining in Dobbs, let's codify privacy and bodily autonomy once and for all and get it out of the hands of 9 justices.
Sounds good to me.
Kelley, some of these Republican states are now talking about preventing people from traveling to abortion-friendly states for their health care. And there's a model state law being developed that would have people becoming abortion vigilantes, turning in those traveling for an abortion and those who are helping them. Is this really possible?
Here's the interesting part of this, and it's messy, but this would be my response. Will the people support those laws? Will they actually support them at the end of the day? That's the democratic process, and that's what needs to happen. If the will of the people is, this is insane, they need to go to the ballot box and they need to get together and by plebiscite make decisions about whether or not that type of crazy talk will actually do. I think this is the opportunity now for people to say the court doesn't get to decide what happens, and state laws that have crazy talk in them need to go. You have to remember, for 50 years, this regulatory environment has been growing and growing and growing and growing with strength. This didn't just happen overnight. So when you're faced with it, sort of the reality of here's the law, there's a lot of people that until last Friday had no idea what their law said.
Yeah.
And I think this awakening is a really positive movement, because the chances that laws that are outmoded and outdated will actually be sustainable or even followed by the people is pretty small.
Yeah.
The people will reject them.
Sum it all up for us. Where does the country go from here?
The most important thing people need to realize, the abortion war is over. It has been lost in the courts. The fight for bodily autonomy and for women and men and everybody to have control over what happens inside their bodies is the war to win. I think we have to take the conversation to the next level, and it has to be about something that affects everybody. And you have to move it above the conversation where moral conflict will never be resolved and will only result in more consternation. You will never convince somebody who believes life begins at conception that abortion is okay, ever, period. So we need to realize that abortion is radioactive. That word is radioactive. We need to move to the next level and talk about choices of health and bodily autonomy. And I'll tell you why. This is for another conversation. The other thing that we don't do well and we need to get really clear on is the difference between a therapeutic and a non-therapeutic abortion. I do not know anybody, and I know a ton of people who are pro-life. I do not know any of them who think that a miscarriage or a stillbirth or an ectopic pregnancy or any of that is abortion. It needs to be removed from the entire vocabulary of abortion. That is healthcare. Deciding to terminate a pregnancy because it's going to ruin your career and you were sloppy on a Friday night is never going to fly. Because what the right is going to say is you do bear some personal responsibility in this, because that pregnancy was 100% preventable. Like it or not, that's the argument. Most therapeutic or medically necessary abortions are for babies that were desperately wanted. Non-therapeutic, many ways, are for babies that were unplanned and that would mess up somebody's life. Got to move the conversation to the next level and have one that men and women can agree on. Not enough people care about abortion. No.
Not enough people care about abortion?
If you're not somebody who,
Okay.
when I say this, not enough people care about it. If you're not a woman who could get pregnant and have her life screwed up by it, this isn't your number one issue.
Kelley, it was great. Thanks for joining us for our podcast. Mark and I are really grateful, and we hope that you guys that are listening learned something today, because I thought Kelley put things in a really great perspective for us to understand. You know, if you haven't already done so, please check out Mark Bellow's Ripped from the Headlines legal thrillers. They're all available online at Amazon and other major online booksellers. He is quite the hero in attorney Zachary Blake, who fights for justice on all fronts. His books are Betrayal of Faith, Betrayal of Justice, Betrayal in Blue, Betrayal in Black, Betrayal High, Supreme Betrayal, Betrayal at the Border, and his latest, You Have the Right to Remain Silent. For more information, just check markmbello.com. Until next time, this is Bob Gaddy from Mark Bello signing off.
Yep.